We're at trial. It's a medical malpractice trial, and the defense lawyer tries to offer in certain medical records into evidence. And I jump up and I yell out, "Objection, Judge! The defense attorney hasn't authenticated that these are accurate medical records." You want to know what this is and why I'm objecting? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now we're at trial. The defense lawyer is trying to get into evidence certain medical records of my client whom he saw years earlier. And now he wants to show the jury that there's something in these records that possibly is damaging to our case. But the problem is, this defense lawyer has not authenticated that these medical records are accurate. This defense lawyer has not authenticated that these are accurate photocopies, which puts us in a bad position. Why? Because now if he's trying to show to the jury that these are some doctor's records, and now he's trying to use those records against us, how do we truly know that they're accurate photocopies? How do we know if they're originals? How do we know that these are accurate business records? Well, the attorney should be going ahead with a process to try and authenticate them. And there are a number of different ways to do that. Number one is to call in the doctor, but in all likelihood, he's not going to be able to get the doctor to come in just to say, yes, these are my records, here's what they show. Instead, you can get in somebody from the office to say, yes, I'm fully aware of how our records are maintained. In response to a subpoena to bring these records into court, I delivered these records to the courthouse. And yes, I checked to make sure that they were absolutely correct. These are the original records. We have no other records. Another more common way to do that is to have somebody who's in charge of medical records in the doctor's office make a photocopy of each and every record that the doctor has, and then attach a certification by the person who's making these photocopies saying, yes, I certify that I have copied these accurately and that there are no other medical records in our possession. And now they sign that, they certify and swear that these are the only records that were made at the time of the copying. And now they submit those into court. And typically, in order to prevent having to call in different witnesses, ancillary witnesses, just to say that yes, these are made in the ordinary course of business, we keep them, we safeguard them, now it's common for the attorneys to agree that yes, as long as you have the certification and nothing else seems to be amiss, now we will go ahead and recognize, yes, these records are authenticated. It's critically important that now, when the records are being introduced into evidence, that we have an opportunity to compare them to the records we had gotten much earlier in the case to make sure that they are accurate and nothing's missing. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and these wrongful death cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.